Okay, so
Introductory concepts in American government. What is the right to privacy? Should the government be able to listen in to your phone conversations? Should the police be able to search your automobile at any time? Should the government be allowed to use drones for surveillance? Should society have the ability to regulate your sexual activity? Each of these is related to the right of privacy that citizens in a free society expect. Most would consider personal conversations, their body, and what they do in their own home private, but the government at times has chosen to regulate these spaces with the goal of keeping us safe. The Bill of Rights lists the essential freedoms and rights of citizens and is the first 10 amendments to the United States Constitution. It includes civil liberties such as the freedom of speech, freedom of religion, and the freedom of the press. It also includes a number of civil rights, such as the right to a fair trial, right to a lawyer, and the right to not self-incriminate. While a number of liberties and rights are included in the Bill of Rights, the right to privacy is not one of them. In fact, the right to privacy was created by the Supreme Court in the 1965 case of Griswold versus Connecticut. The precedent was later applied in the Roe v. Wade decision, which is still being litigated in the courts. Because of this, it has been expanded and contracted by the court over time, making it one of the most controversial rights in America today. Estelle Griswold was the executive director of the Planned Parenthood League of Connecticut. She and the medical director for the league gave information, instruction, and other medical advice to married couples about birth control. Griswold and the medical director were arrested and convicted under a Connecticut law that made it illegal to provide information or medical advice to couples for the purposes of preventing conception. They challenged their conviction in the Supreme Court. This became the case of Griswold versus Connecticut. In reviewing the legality of the Connecticut law, the court had to weigh the interests of the state with the rights of the individual. Specifically, the court considered whether the Constitution protected married couples' right to privacy, and if so, does this right outweigh the state's powers to regulate the health, safety, welfare, and morals of its citizens? Ultimately, the Supreme Court ruled that while it isn't listed in the Bill of Rights, the Constitution contains an inherent right to privacy. This right, the court argued, could be found in the penumbras or shadows of several other amendments, including the First, Third, Fourth, and Fifth Amendments. In the Third Amendment's prohibition against requiring the housing and quartering soldiers except in times of war, the court argued if the government cannot force you to open your home to soldiers, then it must be that your home is a zone of privacy. The court ruled that zones of privacy surround every person in the United States, and the government cannot create laws that encroach upon this zone. Not only did the Supreme Court establish the right to privacy in the Griswold case, but they went a step further in establishing the right to privacy as one of the most fundamental rights to the American system of justice and law. This elevated the right to privacy equal to that of the freedom of speech or religion, guaranteeing it the highest levels of constitutional protection. Several decades after the Griswold ruling, the Supreme Court would consider the right to privacy once again. In the case of Roberts v. USJCs, 1984, the Supreme Court ruled that the right to privacy hinges in large part on the freedom of association, which is protected by the First Amendment's freedom of association. Specifically, the court ruled that the freedom of association protects citizens' intimate and expressive associations. The court's distinction between these two forms of association would help to cement an individual's right to privacy, for example, over their bodies, as well as a collective right to privacy, in the instance of government spying on group communications. In summary, the right to privacy cannot be found in the Constitution, but was instead created by the Supreme Court in the case of Griswold versus Connecticut. The court ruled that while the Constitution doesn't explicitly mention the right to privacy, it can be found in the shadows of other amendments, such as the 3rd, the 4th, and the 5th. The court has expanded these zones of privacy to include an individual's intimate associations, such as between consenting adults, and their expressive associations, such as those of an interest group. That does not mean the right of privacy is without controversy. Consider how Congress empowered policy agencies through the USA Patriot Act, 2001, in the aftermath of the events of September 11th, 2001.
Within that right to privacy clip that you just saw, hopefully you were able to determine kind of what was going on. If not, you can look at the Quimby clip that's on YouTube, or if you need it, I have it and I can send it to you just in case you want to get more information or are interested in it. It's basically a 3-minute video, but it involves Estelle Griswold and the state of Connecticut, and she was the head of Planned Parenthood, and she was giving information regarding contraceptives in '65 to this married couple. The Supreme Court determined that there is a right to privacy that would have protected this couple in getting this information, and they said it's implied throughout the Bill of Rights. Where did they say that you could pick up your right hand and then lower your second finger? It's the 4 others: 1st, 3rd, 4th, and 5th. And sometimes I've heard it just 3rd, 4th, and 5th. So if you see 1, 3, 4, 5, check that as an answer, or if you see 3, 4, 5, check that as an answer as well. And within that decision, they noted the zone of privacy should extend to intimacies between married couples. So you had 2 types of expression that were protected. All right, so let's look at the questions to the answers, and I just recorded again without using my voice, so I've already repeated this. So I feel like I'm lecturing double. So the first question is, the Bill of Rights is referred to as what? And that's the first 10 amendments to the Constitution, which we do. In 1965, what case did the Supreme Court consider whether a right to privacy could be found in the Constitution? And that was this case, Griswold versus Connecticut in '65. So in this case, the Supreme Court ruled that the right to privacy could be found in the penumbras or shadows of which amendments, and it says 1st, 3rd, 4th, 5th. And then the Supreme Court has ruled that privacy includes both intimate and expressive associations. And finally, in Griswold versus Connecticut, the Supreme Court considered whether the right to privacy includes a couple's right to receive information regarding contraception. And I had also told you to remember that not to confuse this case with Burwell versus Hobby Lobby, because that one also involved contraception, but it involved Hobby Lobby not wanting to provide contraception to its employees through their insurance, and they had the right to do so. So don't get these two confused. One involves the right to privacy in '65, which was later used in Roe versus Wade, which was a Texas case, and then okay, so established in Griswold versus Connecticut that Americans have a zone of privacy that the government cannot lawfully invade. That was followed up in 1973. That precedent was cited to by the '73 court, that abortion was protected as a right of privacy as well. And so you've had a lot of back and forth over that issue, and you still have state governments trying to circumvent that ruling. So we saw a lot of that last summer. But these are the cases that used the right to privacy as a precedent. So it was Webster versus Reproductive Health Services in '89, Planned Parenthood versus Casey, and Gonzalez versus Carhart in 2007. And there were some restrictions established as to certain abortions being allowed. So while they have not outright outlawed abortion, they have made several restrictions for people who are seeking to have abortions. All right, we also get into the same-sex topic, and I think it was a Georgia case that was overturned. So I'm not sure of the name of that one, just right off the top of my head. But Lawrence v. Texas overturned that case, and it stated that consensual sexual relations among same-sex adults were eventually protected by the same right of privacy in Lawrence versus Texas. So in Chapter 5, you'll see the trailer for Loving versus Virginia, and so you'll see kind of that same aspect, but it applies to equal rights because the government isn't protecting the individuals based on their race, and so they have a duty to do so, and so the ACLU sues, and it becomes history and precedent making, but we will get to that tomorrow with Chapter 5. All right, as far as being pro-life versus pro-choice, it kind of depends as to whether or not you are conservative or you are a liberal. Those agreeing they would like Roe v. Wade overturned, 44% of Republicans would agree to that, and 14% of Democrats would agree. So sometimes you have agreements between the parties. So 14% of those people actually agree. If you're looking at it from a Democratic perspective. Now, as far as not wanting it overturned, many more liberals don't want it overturned. So it's a hot issue for liberals. 84% don't want this decision overturned. They consider it a woman's right to choose, and they're very vocal about that. Now, you also have, on the other hand, those who protest abortion clinics, and they can be vocal as well, and sometimes you have back and forth going on between the two groups. But as far as not wanting it overturned, 53% of your Republicans would agree to not overturning it. So if this is the consensus, over half don't want it turned over. So I don't see the Supreme Court making a decision to overturn it if this is what the people want. But, the Supreme Court sometimes will do its own thing, and we can't control what they do. All right, now we want to get to the exciting part, rights of persons accused of crimes. And here are my mugshots. Not mine, personally. I don't have any, thankfully. So it involves procedural due process. And procedural due process is making sure that certain procedures are followed every time with regard to the person being accused. So procedures that authorities must follow before a person can lawfully be punished for an offense. So we talked about the writ of habeas corpus. So you have to be told why you're being held, and that's been a thing since the founding of our nation. And we took certain ideas and extended upon them. So it says the U.S. Constitution offers procedural safeguards designed to protect a person from wrongful arrest, conviction, and punishment. So normally I would show you the 3 clips involving these individuals, but I will just send you the links for those so that you can watch them yourself. But the first one involves Miss Dilray Mapp. And I think it was around the later 50s where she was approached by some officers and asked to look into her house. They were looking for a convict. And Miss Mapp at the time told them to go get a warrant, which I thought was very bold of her. And they left. They come back. I don't believe with the correct paperwork that was required, and so she and the officers get into a scuffle. Well, they go ahead and search the home, and in the basement, in some sort of device, they found some form of pornography. So they charged her with having pornography, but they did not find the convict that they were looking for. So the Supreme Court, not the Supreme, well, so they addressed this issue, and they determined that that evidence that they took in, the pornography, had to be excluded from her trial because they didn't ask for her home to be searched, and specifically anything involving that. So that relates back to the exclusionary rule. Certain things have to be excluded if they weren't properly attained, or the proper chain of command wasn't followed. So when I say chain of command, the procedures have to be followed, and if they ever are not followed, there's the potential of an attorney getting wind of that and then having that information removed from the record, and so the jury can't consider that. So that can become a really big issue for the prosecution. This next gentleman is Gideon, Clarence Earl Gideon, and the case was Gideon versus Wainwright. And so he was an older man. He came out of a pool hall, and he had a bunch of dollar bills sticking out of his pocket, and it had been robbed. And so they arrested him, and he asked for an attorney, and they said, "No, sir, you don't get an attorney." And he goes, "Well, I should." And so that began the argument as to whether or not the states had to provide an attorney for the accused, especially in these criminal trials. And the Supreme Court ended up finding on his behalf. And so he was a man of an 8th grade education who wrote the Supreme Court a handwritten letter, and I can find it. I mean, I have it documented somewhere and saved somewhere. But they took his case. So they granted cert to Mr. Gideon, and they heard his case. They agreed with him. They said the 14th Amendment made the 6th Amendment applicable to the states, so the states would have to grant him an attorney, and so it all worked out for him and for some of us, because that was clarified that they couldn't make that argument again. And so that became a nationwide precedent. Anytime you were involved in a criminal case and you needed an attorney, then you would get your attorney if you were in a criminal case. It might not be the best attorney, but you would get a court-appointed attorney. Now, that becomes important because in this next case, this guy is pulled over, and I believe he's guilty of whatever he was pulled over for. I can't remember the exact facts, but this is Ernesto Miranda. So his argument was that he wasn't told that he had a right to an attorney, and he wasn't told that he didn't have to be silent and not give away information. So he was arguing that his 5th Amendment was violated because he incriminated himself, and they didn't tell him that he had the right to an attorney. And so they actually agreed with him on both of those. So just something to consider. Even though these guys may have not been on the up and up, some good decisions can result from that, from people's mistakes, and you move forward as a society with these new rules on the books. Okay, so this list, table 4-2 in your book, gives you some due process protections. So you are protected from unreasonable searches and seizures, but you can forfeit that right if you knowingly waive it. Let me give you an example. And I just learned that COPS is now being taken off the air. I think it's been on the air for 30, 40 years, but I had watched an episode of this girl traveling around in a car, and the cop pulls her over, and he says, "Ma'am, I'm pulling you over because you were playing the radio extremely loud and it's a noise disturbance, so I just wanted to let you know maybe you should turn your radio down." She was like, "Yes, sir, is that all you need?" He goes, "Yeah, unless you got something else to tell me." And she goes, "Oh, no, no. If you want to, though, you can search my car." And he said, "Really?" And she said, "Yeah." And so he went and searched the car, and sure enough, there were drugs in there. So some of these people don't do themselves any favors. And also under the fourth, you're protected from arrest unless the authorities have probable cause to believe that you committed a crime. And so until they have probable cause, they can't make an arrest. Under the fifth, you are protected from self-incrimination, double jeopardy, or being tried for the same crime twice. Now, if you have a mistrial, you can be tried again for that. But if you are found innocent of the charge and the prosecution decides to charge you again, that's just not allowed. So I'm glad they made that clear. And then due process. You can't be deprived of life, liberty, or property without legal proceedings. So if someone were to take something from you, they would have to probably appear before the court, some court, depending on the situation, and depending on who had taken the property. And they would have to give their reasoning in doing so. Number 6, you have the right to counsel. You can have the right to be represented by an attorney and can demand to speak first with an attorney before responding to questions from law enforcement officials. And you are also entitled under the 6th to prompt and reasonable proceedings. So you should be tried shortly. Unfortunately, we have kind of a backlog as far as cases go, and realistically, being tried promptly is not going to happen. So if you go into jail and you don't have bail money, or you don't have anyone to bail you out, you could potentially get stuck in jail during a pandemic. And they said, you obviously have seen the stories where jailed persons having COVID were actually jailed with others. And so the chances of you getting that virus were extremely high, and some actually took video of it. It looked terrible. So I wouldn't want that situation to occur. So if I saw an attorney, I would definitely make a case as far as arguing that I needed a speed and prompt proceeding. And then the 8th Amendment, you are protected against excessive bail, and you are protected against cruel and unusual punishment. It doesn't, however, protect you from the death penalty or from a long prison term for a minor offense. All right, next we look at the suspicion phase. So no police search is allowed unless there is probable cause that a crime occurred. That's per the 4th Amendment. The police have to be granted a warrant. It says the requirement of a warrant has been upheld in cases involving cell phones and similar electronic devices. The only time that they are allowed to search your phones is if they suspect you of terrorist activity. It says next, warrantless searches are allowed in some circumstances, such as school administrators searching for drugs and weapons. And so they'll bring the dogs and the different people in. I've seen that occur. And then you also have police roadblocks to check for intoxication, as long as the action is systematic and not arbitrary. Okay, so these are some of the cases that I spoke about earlier. This is the arrest phase. Okay, so with regard to the arrest phase, you are getting protection from yourself. You don't want to run your mouth and give yourself up. So it's basically trying to help you keep your yapper shut. So the Fifth Amendment protection against self-incrimination says that an individual cannot be compelled in any criminal case to be a witness against himself. So we saw that in Miranda versus Arizona when he self-incriminated himself, and he had argued because he wasn't advised of his rights, and he wasn't advised that he even had a right to an attorney, or he would have used it, and they found in his favor. So I just recently watched it was a Jeffrey Epstein documentary, and so during his deposition, where the attorneys were questioning him as to whether he had engaged in any illegal activity, he continued to deny it, and doing so, sometimes he wouldn't even deny it, but he would say, I assert my Fifth Amendment, I assert my Fifth Amendment, meaning he didn't want to testify against himself. All right. And so in Miranda versus Arizona, that's when they created the Miranda card that some of the police carry around with them, some of your newer police officers, and then some have it memorized and some can quote it, and it doesn't have to be verbatim, but there's no legal interrogation allowed until the suspect has been warned that his or her words could be used as evidence. So I think one of the first things they say is you have a right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be appointed to you. And there's a little more to it, but I'm not going to go through it all, but you get the idea. That came as a result of Miranda contesting his arrest. Now we get into the trial phase. You have a right to a fair trial. So under the Fifth Amendment, you can't be tried for the same crime twice. And you can't be tried for a federal crime unless you were indicted by a grand jury. And states aren't required to use grand juries. That doesn't mean that some don't engage in that. And so the Sixth Amendment, we determined through Gideon that established that the states had to provide legal counsel before and during trial. And it says that also under the Sixth Amendment, criminal defendants have the right to a speedy trial and to confront witnesses against them. So if they think that the person is saying something untruthful, they can in fact cross-examine them if they represent themselves, or their attorney can cross-examine that person. So at the federal level and sometimes at the state level, defendants have the right to a jury trial to be heard by an impartial jury. So impartial juries, people who don't really have a bias in the case. Sometimes you have attorneys who will actually change venue or location because they don't believe they can find an impartial jury. They think that everyone knows about the case, and that becomes problematic for their client getting a fair trial. Now we're talking about the trial phase. You have the right to a fair trial. The exclusionary rule can come up here. Evidence obtained in violation of the defendant's rights cannot be used. So we talked about Ms. Delray Mapp and them finding the pornographic evidence, and then that evidence being excluded from the trial that she was having. And it says examples of where the rules were expanded in the 60s include Mapp versus Ohio, Gideon versus Wainwright, Miranda versus Arizona, and Nix versus Williams. Okay, so with Nix versus Williams, that's when the court found that the defendant, yes, he gave the location of the body up, but it wouldn't have mattered because they would have the volunteers would have inevitably discovered her body. So if that were going to be the case, they could include the evidence and his confession. And the good faith is the good faith exception applies if the police believe they are acting under proper protocol or following the proper procedure. So sometimes that can be allowed. Also, the plain view exception. Now, I talked about that interesting person that tried to take me out on a date with marijuana in the back of his car. That would have been problematic had I actually went on that date, because had the police pulled him over, it would have clearly been in plain view. And anytime the police pull you over and there's something in their plain view, they're not required to get a warrant. They can automatically search if they choose. Sometimes even like the smell of marijuana can be an indicator that there's drugs in the car. Although that's changing kind of with the legalization and the lessening of sentences for lower level offenses. Okay, the Eighth Amendment, we're looking at the sentencing phase, cruel and unusual punishment. So they're going to look at whether the punishment is disproportionate to the offense and whether it violates the standards of good conscience and fairness, or is it unnecessarily cruel. It says the Supreme Court generally allows states to decide the punishments, but has limited some aspects in that it's banned the death penalty for minors and the mentally ill, and it's banned life without parole for juveniles, and extended this protection to juveniles convicted before the ban was put into place. Next, we move on to your appeal phase, and you generally get one of those. So there is no constitutional guarantee of an appeal, but the federal government and the states all allow at least one appeal. The federal law bars a second federal appeal by a state prison inmate in most instances. All right, so now we want to look at crime, punishment, and police practices. So it says some Supreme Court rulings have affected police practices. And so the one case that was especially true for was Miranda versus Arizona, where the police had to start reading the rights to those of the accused before getting them to confess, etc. But it says sometimes your constitutional rights are often applied unevenly. Unfortunately, there have been studies that show that racial profiling is problematic in police departments, and we're certainly seeing protests today based on that. So unfortunately, with regard to racial profiling, those of a different race become the target of individuals who are looking to target minority groups. And it says that minority groups are also more likely to be victims of police violence. So all of that's unfortunate, but thankfully you can learn from mistakes, or you better learn. So I think that, the George Floyd's death has been kind of a wake-up call for our police, in that they need to be careful with how they're acting, especially these days. I watched the arrest, or I tried watching it. It was pretty terrible. So I knew there would be something coming out of that, and so I stayed up and I watched the riots, and I felt like after I'd watched them, I'd committed all kinds of felonies. I could not believe that, some of the reactions, and again, some of the violence was attributed to minorities, and it shouldn't have been. They found that, I believe, 46 men who were Proud Boys or white nationalists were involved in that, in the Minneapolis riots. And they even had one of these individuals on camera busting the windows. I forget for which for which building that was destroyed, but they have him on film, and they had pretty much determined that he was a police from the get-go, and they later confirmed that he was. So this was an actual police officer inciting the riots. Okay, next we want to look at incarceration rates by country. Now this is unfortunately embarrassing for the United States. We are just way above anyone else. The rest of these countries focus more on education and the well-being of others, while we put people in jail. So do we just have that many more criminals than these countries, or is it the approach that we're taking? So I think that the United States needs to take that into consideration as to, you know, maybe there's something that we need to adjust as far as the system is going, and if adjustments are needed, then you would have people look into the studies, do a cost-benefit analysis, and then determine what is needed next, what types of reform are needed. And I believe they're in the works. Some reform is already in the works at the federal level for sure. But it says the United States is the world leader in terms of the number of people it places behind bars, with 666 inmates per 100,000 residents. More than half were convicted of nonviolent offenses such as drug use or property theft. And I don't know if you've ever heard of the term recidivist, but that's a repeat offender. So once one starts going in, unfortunately, they will probably go back. So there's been a lot of studies conducted as to what would prevent these individuals from becoming recidivist. So anyway, hopefully we can get some of those issues figured out so that we're not so ahead of everybody as far as incarceration rates and people not being able to afford bail and getting stuck in COVID virus prisons and dying as a result of maybe having, a small charge brought against them, but not being able to afford bail. I think that would be considered cruel and unusual to make a person, or to subject a person to spending the night in a COVID virus jail with people having it in your cell when you committed just a small offense. It just seems problematic to me. All right. How the 50 states differ as far as incarceration rates. If you notice, up at northeast area, you have the lowest amounts. Also, Washington, if it's cold enough, people aren't going to commit crimes. Look, down south, you've got lots of, the incarceration rate is higher. But this is also economically more disadvantaged than the other places that I'm referencing. So you have to take into a lot of considerations when you're looking at the makeup. No one really beats Louisiana. Louisiana comes out ahead. It says Louisiana has the highest incarceration rates at 1,380 inmates per every 100,000 residents. So I thought that was pretty amazing. It says most crimes in the United States are governed by state law rather than federal law, and states differ wildly in their crime rates and their sentencing practices. So, okay, so we want to look at the rights, your rights when you have a war on terrorism. So in times of war, the courts have upheld practices that would not be permitted otherwise. So in World War II, they permitted the detention of Japanese Americans. They feared that they might potentially have some unsavory agenda in being in the United States. And so they were detained and put into internment camps. And so that decision was Korematsu versus the United States. Now, since that decision, we've had the Supreme Court speak negatively about that decision, but they haven't outright reversed it. But I believe one justice, I think it's Sotomayor, but I'm not sure, she or the other person that was quoted as saying it was, with that being said, the negative talk about Korematsu, she couldn't believe, she wouldn't believe that today that Korematsu precedent would be allowed or permitted. So that was a good thing to hear, and hopefully that decision would not be permitted today. And enemy combatants are allowed. The problem with that is determining whether or not someone is an enemy combatant. So after the attacks of 9/11, the Bush administration announced a policy of detaining enemy combatants. The Supreme Court ruled that detainees have the right to challenge their Guantanamo Bay detention in the U.S. courts. That was under Hamdan versus Rumsfeld in 2006. And I have this clip if you would like to watch it as well, but simply knowing that the detention of enemy combatants, that they have that right to challenge their detention in that situation, because a lot of these individuals were being held for no reason. And then they had a no-flight list, or people who went on a no-flight list, and it included congressmen. So they had to fix that issue as well. All right. So they also allow surveillance of suspected terrorists. The problem with that is you have Edward Snowden, who worked for the NSA, who came out and said, well, you know, they're doing other things as well. They're not just looking at terrorists. So he had advised that the NSA was engaged in warrantless wiretapping, and that was in 2013. So a federal appellate court ruled that the NSA program was unlawful, and then Congress passed some revised legislation to authorize a more limited surveillance program with greater oversight. And so there's a lot of controversy surrounding Edward Snowden and Julian Assange today. And his quote here is, "If I'm a traitor, who did I betray? I gave all my information to the American public, to American journalists who are reporting on American issues. If they see that as treason, I think people need to consider who they think they are working for. The public is supposed to be their boss, not their enemy." And so there's a trailer that I could show you here, and I forget the name of the actor, but he played Edward Snowden. It was the guy, I can't remember his name, but the trailer is available too, and I can give you that as a link if you would like, or you can look it up on YouTube yourself. But you can always learn things about government in watching the movie. Just don't take everything as fact. There's probably some things in that movie that aren't factual, that are kind of just been added in there to gain viewership. So that's the one thing that you need to be cautious about in watching those movies. Okay, this was just happened the other day. So the Senate passed a surveillance bill without banning of web history snooping. So that occurred on May the 14th of 2020, during the pandemic, during all of this presidential election insanity, and then we're now officially in a recession. So a lot of things were going on, and so people learned of this after the fact, and they became upset, and they said, what, they're going to be able to snoop on our web history? How can they do that? And so anyway, this kind of talks to that, or speaks to that. So if you'd like to read about it and get a little bit more information, it's there. So it's the USA Freedom Reauthorization Act. So the US Patriot Act is off the books now. It expired in March, but now you have this Reauthorization Act. And it's basically was meant to reform the Patriot Act. So anyway, there was a lot of backlash about Congress or the Senate passing this bill, just basically as a result of the timing. All right, Americans embrace freedom of expression as an abstract virtue. Americans favor limits to freedom of expression in particular instances. And the judicial system has been the primary protector of individuals' rights. And this is almost always a test question, so I want you to pay particular importance to it. Who is the primary protector of individual rights? The judicial system. So Earl Warren with Gideon, Earl Warren with Miranda. I'm not sure about that 59. I think Matt v. Ohio might not have been him, but it was close. It might have been him too. So the 60s definitely was a time period when the judicial system was looking out for individuals and protecting them. So this is interactives that you can complete. It might help you in looking at them to get the answers. And then this is talking about the variation between civil liberties and civil rights. So the Bill of Rights falls under your civil liberties. Your civil rights would fall under the 14th Amendment. And the 14th Amendment applies to what the government must do to ensure equal protection. And so we'll look at some very interesting cases with regard to equal protection, and very timely cases because of what's going on as far as these protests after the George Floyd murder. All right, and then we've already went through the civil liberties and what they include, but the legal constitutional protections against the government, the limitations on governmental power, and what the government can't do. And then when you look at civil rights, it's what is the government required to do, and is it protecting against discriminatory treatment, because it should be, and if it isn't, it's going to be problematic. All right, so that kind of sums up Chapter 4 with civil liberties, and we will move on to Chapter 5, civil rights. Hopefully you'll get that lecture soon. I'm going to send it off and get that right back to you. Have a good one.